Over recent years, there's been a problem for immigration practitioners in respect of applications under the points-based system. The strict requirements of PBS applications and Section 85A, which prevents further evidence on appeal, has led to problems. And there's been two things that have been our saviour, and they're two F words. That is flexibility and fairness. Although over the last few months, they've both been under attack. In terms of flexibility, the case of Rodriguez has curtailed the sort of success of using the evidential flexibility policy. Now, there's a new case that came out today on the 26th of November that seems to be a negative judgment in terms of fairness. And that's the case I want to talk to you about today. It's called EK Ivory Coast, and it's EWCA Civ 1517, and it's a decision of the 26th of November 2014 from the Court of Appeal. Now, this case concerns an applicant under Tier 4 of the points-based system who submitted a CAS, and between submitting the application and the decision that was made by the Home Office, her college, due to an administrative error, withdrew the CAS. So her application was refused, and then on appeal, her appeal to the first tier was dismissed and to the upper tier. She got permission to the appeal to the Court of Appeal, and the question before the Court of Appeal was, did fairness in this situation demand that the Secretary of State should pause consideration of her application and contact her to find out what had gone on in respect of the CAS and give her a chance to explain things? The leading judgment was from Lord Justice Sales, who dismisses the appeal. But this case is interesting because there's a dissenting judgment from Lord Justice Floyd. And I think this case is ripe for going to the Supreme Court because of this dissenting judgment. It's interesting also to note that there was little discussion in this case of the effect of Section 85A and the inability of applicants to put in further evidence on appeal. And I think the context of fairness should have considered the effect of Section 85A. But anyway, in respect of the judgment of Lord Justice Sales, he says a few things that I want to draw your attention to. Let me read you paragraph 28. He says this: the PBS is intended to simplify the procedure for applying for leave to enter or remain in the United Kingdom in certain classes of case, such as economic migrants and students. This is to enable the Secretary of State to process high volumes of applications in a fair and reasonably expeditious manner, according to clear objective criteria. This is in the interest of all applicants. It also assists applicants to know what evidence they have to submit in support of an application. And he says that the context informs the way that fairness should operate. So the context of the PBS scheme should inform how fairness operates in a case such as this. He goes through the authorities and reviews the authorities in relation to fairness, and he finds that the Secretary of State could not be faulted. The fault was with the college in this case. And he distinguishes cases like Thacker and Naveed, saying, well, in those cases, the Secretary of State had initiated the action that had led to unfairness. In this case, he says the Secretary of State was entitled to rely on a registered college saying that the CAS was no longer valid, so there was no unfairness. Interestingly is what Lord Justice Sales says about the case of Naveed. He says this at paragraph 39. In Naveed, the head note summary of the decision drafted by the upper tribunal states, fairness requires the Secretary of State to give an applicant an opportunity to address grounds for refusal of which he did not know and could not have known, failing which the resulting decision may be set aside on appeal as contrary to law. It might be said, says Lord Justice Sales, that the principle as formulated in that summary, the appellant in the present case should have been given notice of the problem with a CAS letter and an opportunity to deal with it. And then paragraph 40 says this: if the upper tribunal intended to lay down a principle formulated in that bold way, I disagree with it. And he says that fails to appreciate the context-specific nature of fairness. So there's a bit of a watering down, particularly of the head note of Naveed in this judgment by Lord Justice Sales, and he goes on to dismiss the appeal. Lord Justice Floyd says, well, I disagree. There were new facts that the applicant was not aware of and should have had an opportunity to address, and therefore I think fairness did demand that the Secretary of State paused and contacted her for an explanation. Unfortunately for the appellant, Lord Justice Briggs follows Lord Justice Sales and the appeal was dismissed. But you have this split Court of Appeal decision, which I think is ripe for going to the Supreme Court on the issue of fairness and the points-based system.